All right, this is part two, beginning at page 236. This is involves the waiver of Miranda rights. So we've all familiar with the way that rights are read to someone, um, especially if that's at the time of their arrest. But if you're in a custodial or in a interrogation situation, an interview with a detective, they're going to most likely have a um, a written Miranda waiver, and there's a requirement that the state establish, and that the interrogator extracted a knowing and voluntary and intelligent um, waiver of a known right and privilege. So here's the gold standard way to do it. If you've got a printed form, you read it, have the person initial it, initial, you know, sentence one about you have the right to remain silent, and anything you do say can be used against you. Have them initial that. Go on to the attorney, initial that. The other thing that really good investigators do is have the person, read. In other words, they will read the right, say, "Do you understand?" And if they say yes, and say, "Okay, tell me what that means." And if the person explains it back in an intelligent way, um, they've more or less established step by step that the person understands the rights and is waiving them knowingly and intelligently. Um, and sometimes people do it that way, sometimes they don't. Um, so one thing that is done sometimes um, is a challenge to an intelligent knowing waiver done by a specialized competency um, test for Miranda waivers. Are you competent to stand trial? We're familiar with that kind of evaluation, but there's a separate test. I can't recall the name of it right now. That is used by psychologists to test, in particular, the understanding of those um, rights that to you and to me seem very, very simple and basic. Um, um, the other thing is, if you're dealing with someone whose English is not good, um, is their waiver intelligent and knowing? One hint of caution from the early days of when there began to be a lot of Spanish speakers in police jurisdictions where that was new, say in Decatur 20 plus years ago when I came back to town and started practicing law. You had somebody who may have spoken Spanish. Maybe they weren't a native speaker, but maybe they were from Texas and they learned some amalgamated language, or they Tex-Mex as they call it sometimes, or they had a high school Spanish class knowledge of Spanish, and they would call on that officer to translate. And we had a form that was in use in Decatur for a while that used the wrong verb to say appoint a lawyer. The verb actually in Spanish meant to point to a lawyer, which um, obviously is very confusing. You might point to them, but uh, I'm still too broke to afford a lawyer. Whereas if they'd used the right verb, and I don't know which one that is, to say assign or appoint a lawyer, um, it would have been perhaps a knowing waiver. But we actually got a statement suppressed because the Spanish speaker was looking at essentially nonsensical, a nonsensical translation. Um, so, um, so when you invoke the right to remain silent, let's look at how that may be treated differently from if you invoke a right the right to an attorney. Uh, if you say, I choose to remain silent, and that's all you say, um, then the police have to honor that, but they can question you about, you know, perhaps they let things cool off and come back and question you about another offense. Then they have not violated your right to silence about the things they were questioning you about hours before, for instance. However, if you request an attorney, the police cannot approach you about another offense like they could if it was simply an invocation of the right to silence. If you invoke the right to an attorney, um, they cannot approach about a separate investigation until you've had an opportunity to consult with an attorney. The quote from the Arizona v. Roberson case, as a matter of law, that means, listen closely, this is a rule. As a matter of law, the presumption raised by a suspect's request for counsel that he considers himself unable to deal with the pressures of custodial interrogation without legal assistance does not disappear simply because the police have approached him about another um, investigation if he's still in custody and still without counsel. Now, that said, a person can reinitiate contact with the police in either situation. If they say, I want to remain silent, the police have to leave you alone about that investigation, but you, as the suspect, can begin talking again. Likewise, if you invoke your right to an attorney, you can reinitiate contact with the police. They don't have to remind you that you invoked counsel. They can simply see that as a withdrawal of your waiver. All right. There is a discussion here about if you're if a person shows up and says, I am that person's lawyer, I want questioning to stop, and I want to see my client, the police don't have to let you do that because the person themselves, they have to request a lawyer. Just the lawyer showing up, and they can't barge in and stop things. There has to be a request. So another point to be made is that the police, if you've had the Miranda warnings, and if a person has not invoked or has not waived, there may be circumstances where the police can go on to ask questions, and your decision to speak would be an implicit waiver of rights. So if you speak, if you proceed without an attorney, it can be an implied waiver that you don't wish to remain silent and you don't wish to invoke your right to an attorney. Okay. I want to make this point about in the situation where a right to counsel is invoked after a Miranda warning. If you're going to make the police stop and have a court enforce that later, there has to be what is called an unequivocal waiver, or rather, an unequivocal demand for an attorney. That doesn't mean something along the lines of, do you guys think I need a lawyer? Or I might need a lawyer, despite um, the gravity of that situation. I might need a lawyer is a statement that is different in kind from, I might like Chinese food over Italian food. So um, I'm not sure that's entirely, um, again, that fair play business is not the issue. It's is the law violated? So there's a difference between, um, I might want chocolate ice cream and I might need my heart medicine. All right, there's a sense of urgency, but the court just says might and may and should, and questioning the police about whether I should get a lawyer is not an invocation. So make a very clear demand for a lawyer if you're in that situation, or if you're looking at a suppression issue. It's is there a clear request for a lawyer, not merely some ruminations about whether it might be a good thing to have a lawyer. Look also at this right to counsel that exists outside of Miranda, this Messiah, Massiah versus United States. Um, that that case involved a non-custodial situation because the person was out on bond, but the judicial proceedings had commenced. The person, I believe, had been indicted, um, but they were out on bond, so it wasn't a custodial interrogation. This undercover agent that was sitting in a vehicle with somebody and recording their statements. Um, and so there's a circumstance presented in this case of Brewer versus Williams that is different from the Rhode Island versus Ennis case, turning on the fact that in Brewer v. Williams, an arrest warrant had issued and a person um, had been arraigned, but they nonetheless, the police who were transporting them from Davenport, Iowa, back to Des Moines, Iowa, which is apparently a long car ride, 160 miles, I believe it said, um, were aware of the initiation of judicial proceedings. And the person said something to the effect of, once I get back to Des Moines, Iowa, and I talk to Mr. McKnight, my lawyer, I'm going to tell the whole story. Well, then, knowing this person's, religious beliefs and predispositions, they began to remark um, about what a shame it is that the child that was abducted from his or her parents on Christmas Eve would not get a Christian burial, and once the snow falls, we'll probably never be able to find the body. And this works on this guy. They, who was very religious. They even called him Reverend, and that was said to be a violation of the Sixth Amendment right to counsel because the person had invoked their right to counsel by saying, my lawyer is Mr. McKnight. And was this interrogation? It certainly was action on behalf of the police that was meant to evoke a response from this person, and they suppressed the statements or the person leading the testimony about the person leading them to where the body was, therefore indicating guilty knowledge of the crime. I want you to take note of this Montejo versus Louisiana case. It's kind of a tricky situation. If a state appoints a lawyer to a indigent defendant who has not requested a lawyer. The police may nonetheless question that suspect, even though they have a lawyer. But if that appointment of the lawyer was made just as a matter of routine and not in response to a request for a lawyer, seems like some serious sophistry going on there. But it turns on the issue of whether or not the lawyer themselves have been requested. The there's also a discussion here about jailhouse informants. If if they are agents of the state, um, they cannot interrogate, even in the guise of "I'm just your cellmate here." But they can listen to anything that the person says, and then certainly if a just a straight up snitch comes to the police or the prosecutor and says, you know, this person said whatever, and did you ask him questions? We asked him questions, but you weren't doing it at the uh, insistence of the state, then that is not a custodial, or rather, that's not an interrogation, because that person is acting on their own volition, not as an agent of the state. So that's one of the things I caution my clients about so often is don't talk to anybody. Don't share your discovery with anybody. That's if a client insists on having discovery in their possession. I think it's dangerous because then a cellmate can read the discovery, make up one or two plausible details with a background of things that the police think or know are true. Then all of a sudden you've got the police running with what they say is a confession made by your client because a person um, has had access to the details of their case. Um, so it's not only a matter of not confessing to your cellmate, just don't talk about the details of the case with a cellmate. We should warn our clients about that. To say nothing of the fact that phone calls and video visits that are so ubiquitous now are recorded, and you're warned about the fact that they're recorded in writing as you look at the phone, and um, oftentimes as the call is put through, there's a recitation. This is a call from so and so jail, and the calls are being recorded. So everybody's on notice about that. All right, the issue of corroboration of confessions. There used to be a requirement for the corpus delicti, the um, the body of the offense itself, being established by the evidence, um, being a requirement to corroborate a confession. So I want to make this distinction that's now made in the case law. There just has to be evidence supporting the trustworthiness of the confession, not the corpus delicti. For instance, if you confessed, as the book talks about, to smoking cocaine and in an apartment, and they search the apartment, there's no cocaine residue. Okay, then the corpus delicti is missing, but they nonetheless find um, drug paraphernalia. And now, in this case of Opera versus the United States, OPPER, that is sufficient corroboration of the trustworthiness of the confession, even though the object of the crime, the cocaine, was in fact not found. Um, all right, so next we move to suppression of illegally obtained confessions. Um, I want to go back quickly and alert you to something that I know I didn't mention. Look at this sidebar um, on page 232. this case of Salinas versus Texas, where pre-invocation silence or silence with no invocation of the right to remain silent can be used to impeach a person if they didn't assert their right against self-incrimination. Or they can not only for impeachment, but if there's a means by which that silence would be substantive evidence of guilt. But once that could be used against you. But once you invoke your right to silence, then it can't be used against you. Then the jury it cannot be suggested to the jury that they could make an inference one way or the other about your right to remain silent. Okay, so back to suppression of illegally obtained confessions. Look at the distinction that's made about confessions that are deemed to be involuntary and the suppressibility of a subsequent confession or some evidence that an involuntary confession leads to. If it's involuntary, everything that results from the involuntary confession is tainted and therefore suppressible. However, if it's only an issue of violating the Miranda warnings, it is only the statement that remains inadmissible, and derivative evidence can be used if it's just an issue of Miranda warnings being violated, unless there can be shown a pattern of orchestrating a confession, a Miranda warning at that point, and then some covering the Miranda, the pre-Miranda confession, orchestrating the timing of Miranda warnings to prompt a person to incriminate themselves, and then go, oh, we need to give you these warnings. Now, what was it that you said? All right, that kind of thing, that subsequent or second confession could come into evidence unless there's a pattern of abuse that's shown. Also look at the circumstance where an involuntary, a confession that happens as a result of a Miranda violation, it can be used for impeachment, whereas an involuntary confession cannot. So let's take, for instance, a person gives an unwarned, that is a confession without Miranda warnings. It doesn't come into evidence against them. But if they take the stand and contradict what they've said to the police in an unwarned confession, the prosecutor can say, but isn't it true that you told the police this other set of facts that you're now contradicting as a means of impeachment? The theory is you have the right to take the stand, but you don't have the right to commit perjury. Look at this issue of third-party confessions. The situation where a prosecutor uses an accomplice testimony or confession, the person has to be available. The person who made the confession has to be available for cross-examination, or else the separate right of confrontation, the confrontation clause, is violated if the person is not there subject to cross-examination. Further, the court has to inform the jury that there must be sufficient corroboration or support for a co-defendant's confession or statements that are inculpatory, that is, pointing to the guilt of the other defendant, because co-defendant accusations, even if they themselves put themselves into a crime, but the accusation against the co-defendant, especially if it's the co-defendant is the one that did the shooting or the co-defendant set up this situation or whatever, is inherently unreliable. And so there must be something else in the state's case to corroborate, to support that co-defendant's statement before the jury can consider it as evidence of guilt against the defendant. Um, Now, there's the situation where um, a, a defendant themselves may want to use a, a statement of a co-defendant that admits the person admits to committing the crime, and somehow the circumstances of the crime would lend itself to one party's confession tends to clear the other. Now, the state does not have a right of confrontation. The accused has the right to confront, so that can be used, um, but it can't be used at a joint trial where that co-defendant may well not wish to take the stand, and um, if that um, statement was taken involuntarily or uh, in violation of Miranda. So if it's not coming into the case against the co-defendant, the defendant can't use it to exculpate or exclude themselves, and oftentimes that drives the need for for separate trials, what's sometimes called a motion for severance. But because of the problems that arise with joint trials, um, for instance, the use of a properly taken confession by a co-defendant who's not going to testify, but who nonetheless implicates a co-defendant, that can't come in a joint trial either. And but because of the confrontation clause, the confrontation right of the co-defendant. Um, and so there's oftentimes a way to that under limited circumstances you can rewrite the confession and omit references to the co-defendant, or redacting the statement. But if it just begs the question of, like, there's this other person, there's me and this dude, and there's the person confessing, and then this other guy who's just got to be that other guy, then there's no way to try those people together, because there's no way to redact the statement or rewrite it so that there's not an invitation to fill in the blank with the name of the non-testifying co-defendant. All right, so they're going to be three parts. I'm going to end part two here, and then we're going to finish the chapter up in the third lecture. All right.